The courtroom went completely still the moment she walked through the door, not because she was loud, not because she made a scene. It was the opposite, actually. She was quiet in a way that made people uncomfortable. 43 years old, wearing a gray blazer that had seen better days, carrying a manila folder held together with a rubber band. Her name was Loretta Caine, and she looked like someone's aunt who'd taken a wrong turn on the way to a PTA meeting. The bailiff almost didn't let her pass the door. "Ma'am, this is a restricted area. Are you here for the 11 o'clock hearing?" "I am the 11 o'clock hearing," she said. He looked at his clipboard, looked at her, looked back at the clipboard. Somewhere behind her, a man in an expensive suit actually laughed. That man's name was Preston Holt. He was the lead attorney for Arcadia Financial Group, one of the most powerful private equity firms in the southeastern United States. He had 3 associates beside him, a paralegal, and a cart of documents so heavy it had its own wheels. He had been in this building more times than most people eat breakfast. He knew the judges, the clerks, the security staff by first name. He had never, not once in 22 years of practice, lost a case in this county. He looked at Loretta Caine the way a cat looks at something that wandered in from outside. Mildly curious, vaguely disgusted, already bored. What Preston Holt did not know, what nobody in that room knew yet, was that Loretta Caine had spent the last 3 years of her life preparing for exactly this moment, and she only needed one document to end him. Let me tell you how we got here. Loretta grew up in Crestfield, Georgia, a small city that exists mostly in the space between the places people actually want to go. Her father, James Caine, ran a dry cleaning business on Alderson Street for 31 years. He built it from nothing, one machine, a rented storefront, a handwritten sign in the window. By the time Loretta was in high school, James had 4 employees and a loyal customer base that stretched across 2 zip codes. He was not a wealthy man, but he owned something, and in Crestfield, that meant something. The trouble started in 2018. A company called Arcadia Financial Group had been moving through Georgia's smaller cities the way water moves through a cracked foundation, quietly, steadily, until one day you look down and realize the floor is gone. They specialized in what they called community investment, buying up underperforming commercial properties, redeveloping them, attracting new business. It sounded good on paper. It sounded like progress. What it actually meant was this: identify blocks of small, independent businesses, offer the landlords above-market rates to sell. Once the landlords sold, don't renew the commercial leases. Bring in the chains, rebrand the block, raise the rents. Call it revitalization. James Caine didn't own the building he worked in. He never had. He'd leased it from a man named Harold Purcell for 22 years, and Harold Purcell had always renewed without drama. Every 3 years, same terms, a handshake and a signed paper, and that was that. In March of 2018, Harold Purcell sold his portfolio of 6 Crestfield properties to Arcadia Financial Group for $2.3 million. He didn't tell James ahead of time. He didn't think he had to. The sale went through on a Tuesday. On a Wednesday, James got a letter in the mail on Arcadia letterhead explaining that his lease would not be renewed at the end of the current term, which was 4 months away. 4 months. 31 years of business. 4 months to find a new location, move equipment worth nearly $40,000, rebuild a customer base, and somehow not lose the people who depended on him to pay their own rent. James Caine tried. He spent 2 months looking for alternate spaces. He found one, smaller, worse location, higher monthly cost, and applied for a small business loan to cover the move. He was denied. His credit history was good, his business financials were solid, but the loan officer told him the collateral wasn't sufficient for the amount he needed. He spent his savings. He borrowed from his sister. He was 6 weeks into setting up the new location when he slipped on a wet floor in the back of the half-renovated space and tore 2 tendons in his left knee. Surgery. Recovery. 6 weeks off his feet. By November of 2018, James Caine's dry cleaning business 31 years, 4 employees, the handwritten sign that had been replaced with a proper one but was still in the back closet somewhere, was gone. He didn't file for bankruptcy. He settled his debts slowly, painfully, over 2 years. He got a job as a receiving clerk at a warehouse outside of town. He was 61 years old. He didn't complain. He wasn't built for complaining. But his daughter was watching, and Loretta Caine was built for something else entirely. Here is what people who knew Loretta as a child would have told you. She was the kind of girl who read the entire instruction manual before touching anything, who kept receipts, who once, at age 11, corrected her 6th grade teacher's math in front of the entire class and then apologized so politely afterward that the teacher couldn't even be angry. She had gone to college on a partial scholarship, studied business administration, and then spent 15 years working in commercial real estate compliance for a mid-sized firm in Atlanta. Not flashy work. Not the kind of career that makes people say, "Oh wow," at dinner parties. But she understood contracts. She understood how commercial property transactions were structured, documented, disclosed, and, when necessary, how they fell apart. When her father lost his business, Loretta drove down to Crestfield that weekend and sat at the kitchen table with James while he showed her the paperwork. The lease, the renewal history, the letter from Arcadia. She asked him one question. "Dad, did Harold Purcell ever give you a right of first refusal?" James frowned. "A what?" "When you first signed the lease, did he offer you the right to buy the building if he ever decided to sell?" James pulled out a folder he kept in the cabinet above the refrigerator, the folder where he kept every document related to the building going back to the original lease. He didn't find a right of first refusal clause. But he found something else, something small, something that had been sitting in that folder for 22 years without anyone noticing. Loretta read it 3 times. Then she sat back in the chair and was quiet for a long moment. "Dad," she said, "I need to borrow this folder." What she had found was a single paragraph buried in the 5th page of the original 1997 lease agreement. It was the kind of language that real estate attorneys call boilerplate. Standard, generic, easy to overlook. The kind of paragraph that gets copied from document to document and rarely means anything. Except this one did. The paragraph stated that in the event of a property sale to any party during the lease term or within 6 months of lease termination, the current commercial tenant would be entitled to written notice no fewer than 90 days prior to the completion of the sale and would have the right to match any qualifying offer within 30 days of receiving such notice. Harold Purcell had sold the property to Arcadia Financial Group. The sale had completed in March of 2018. James Caine's lease was not set to expire until July of 2018. Which meant, at the time of sale, James was still an active tenant. He had received no notice, not 90 days before the sale, not 60, not 30, not 1. The letter he received, the one on Arcadia letterhead announcing that his lease would not be renewed, arrived after the sale had already been completed. They hadn't just failed to notify him. They had violated a contractual right he'd had for 22 years and never known about. Loretta took the folder back to Atlanta. She spent 6 months researching. She made copies, organized a timeline, cross-referenced the county property records, pulled the sale documents from the public filing database, and built a paper trail that she kept in a series of labeled binders in her spare bedroom. She talked to 2 attorneys. The first told her the case had merit, but was too small for him to take on contingency. The second told her that fighting a company like Arcadia was expensive, exhausting, and rarely worth it for a single property. She thanked them both and went home. Then she filed the suit herself. She was not a lawyer. Let's be very clear about that. Loretta Caine had a bachelor's degree in business administration and 15 years of professional experience in commercial real estate compliance. She had no law degree, had never passed a bar exam, had never litigated anything in her life. What she had was the right, as an American citizen, to file a civil suit in her own name and represent herself. And she had 3 years. 3 years of evenings, weekends, early mornings. 3 years of legal databases and library books and YouTube videos of law school lectures and online forums where former paralegals answered questions for strangers. 3 years of making mistakes, going back, correcting them, trying again. 3 years of writing motions, having them rejected by the clerk's office on technicalities, rewriting them, filing again. The opposing counsel, Preston Holt's firm, had filed 3 motions to dismiss in those 3 years. She had responded to all 3. The court had denied all 3 dismissals. By the time the case reached its hearing date in the spring of 2021, Loretta had filed 47 separate documents with the court. She had a 3-inch binder of organized evidence. She had a timeline printed on paper, long enough to unfold across a dining room table. And she had the paragraph. The hearing was scheduled for 90 minutes. Preston Holt arrived with his team and his rolling cart and his years of experience and his certainty that settled around him like a good suit. He had reviewed the case, of course. He had seen Loretta's filings, the pro se designation, the business administration degree. He was prepared to be efficient. This was the kind of thing he settled before lunch and forgot about by afternoon. He was not prepared for Loretta Caine. She sat across from him at the plaintiff's table with her rubber-banded manila folder and a legal pad, and she did not look nervous. She looked, if anything, patient, the way someone looks when they have been waiting for something for a very long time and have made peace with the wait. The judge was a woman named the Honorable Rosalie Dempsey. She had been on the bench for 16 years. She was not, as a rule, impressed by much. When she came in and looked at the 2 tables, the rolling cart on one side, the manila folder on the other, something flickered briefly across her face. Not pity, more like attention. "Miss Caine," she said, "this is a pro se civil proceeding. I want to make sure you understand the process today." "Yes, Your Honor," Loretta said. "I do." Holt's opening was what you'd expect, polished, structured, confident. Arcadia had acted in accordance with Georgia commercial property law. The lease in question had no surviving provisions that created an affirmative obligation on the part of the acquiring company. The clause the plaintiff referenced was boilerplate language that had no legal force because Harold Purcell, the original lessor, had not been a party to the assignment of obligations in the transfer of title. Furthermore, the plaintiff had suffered no compensable harm. The business, he pointed out, had closed due to factors unrelated to the property transition. He used the word plaintiff 18 times in 20 minutes. When it was Loretta's turn, she stood up and opened her folder. She put 3 documents on the table in front of her. Just 3. She did not move toward the judge's bench dramatically. She did not raise her voice. She spoke in the same tone you'd use to explain something to a colleague over a lunch table. "Your Honor," she said, "opposing counsel has argued that the clause in the original 1997 lease has no surviving legal force because of the structure of the title transfer. I'd like to address that directly." She picked up the first document. "This is the original 1997 lease agreement between Harold Purcell and my father, James Caine. Section 5, Paragraph 4 contains the notification and right-to-match clause I've referenced in my filings." She put it down. She picked up the second document. "This is the assignment and assumption agreement from Arcadia Financial Group's acquisition of the Purcell property portfolio, filed with the Tarrant County Clerk's Office on March 14, 2018. She put it down. She picked up the third document. "This is the standard commercial lease assumption addendum that Arcadia Financial Group uses in all portfolio acquisitions in the state of Georgia. It is their own form, their own language. Their attorneys drafted it." She held it up so that Judge Dempsey could see it clearly. "This addendum," Loretta said, "states, and I'm reading directly, that the acquiring entity assumes all rights, obligations, covenants, and conditions contained in any existing commercial lease agreements within the portfolio, whether express or implied, as of the effective date of transfer." The room was very quiet. Opposing counsel argued that the notification clause was not binding on Arcadia because Purcell was not a party to the transfer of obligations. Loretta set the document down, but Arcadia's own acquisition agreement says differently. They assumed all obligations, their word, their form, their signature. She looked at Preston Holt. So here is my question, Your Honor. If Arcadia assumed all obligations under the lease, including the obligation to provide 90 days written notice before completing a property sale to any outside party, why did my father receive his first communication from Arcadia 11 days after the sale had already closed? The silence lasted about 4 seconds. Then Preston Holt started speaking, and the composed, efficient man who had arrived that morning began to sound, for the first time, like someone who was not entirely sure where he had put his footing. He argued that the addendum was a general assumption clause and could not be read to extend specific provisions not explicitly transferred. Judge Dempsey asked him to clarify which provisions Arcadia had assumed, if not all of them, given the language of their own addendum. He said that was a matter of interpretation. She asked whose interpretation he was suggesting should override the plain language of the document Arcadia's own legal team had drafted. He said it was more nuanced than that. She looked at him for a moment. Then she looked at Loretta. Ms. Caine, she said, do you have anything to add? Loretta shook her head. I think the document speaks for itself, Your Honor. Judge Dempsey took a 30-minute recess. When she came back, she did not take long. She found that the notification and right-to-match clause in the original 1997 lease was a binding covenant that transferred to Arcadia Financial Group upon their assumption of the Purcell portfolio, as evidenced by their own acquisition addendum language. She found that James Caine had not received the required 90 days notice, that he had in fact received no pre-sale notice whatsoever, and that this constituted a clear breach of his contractual rights. She ordered Arcadia Financial Group to pay James Caine $87,000 in damages, the assessed value of the business loss directly attributable to the abrupt lease termination, including equipment relocation costs, lost client revenue during the transition period, and what the judge described as the quantifiable harm of a forced business closure under unlawful circumstances. She also ordered them to cover Loretta's legal costs, which, since Loretta had represented herself, amounted to filing fees, document retrieval costs, and the price of 3 years' worth of printer ink. Preston Holt walked out of that courtroom with a cart full of documents and a loss that would be difficult to explain to his client. Loretta walked out with her rubber-banded folder and her legal pad and called her father from the parking lot. James Caine was at his warehouse job when his phone rang. He stepped outside into the afternoon heat and listened to his daughter tell him what had happened. She said it plainly, the way she said most things, just the facts, just the outcome, no drama. There was a long pause. Loretta, he said. Yeah, Dad? Another pause. You didn't tell me you were doing all that. I know. 3 years? Give or take. He didn't say anything for a moment. She could hear the ambient sounds of the warehouse lot behind him, a truck backing up somewhere, the beep of a reversing vehicle, birds. You sound like your grandmother, he said finally. She never told anybody anything either, just did the thing. Loretta laughed. It was a short laugh, and she pressed her hand to the side of her face, and for a moment she stood in that parking lot outside the courthouse and didn't say anything either, and that was fine. There is a version of this story that gets told at dinner tables sometimes, as an inspiration. The lone individual against the corporation. The little guy who won. I want to tell you what it actually looked like. It looked like Loretta Caine falling asleep at her kitchen table with a legal textbook open in front of her. It looked like calling the county clerk's office for the 6th time to ask why a filing had been rejected and getting a different answer from a different person each time. It looked like driving 4 hours to Crestfield for a holiday and still spending half of Saturday in her old bedroom with her laptop, cross-referencing property records. It looked like self-doubt. 3 years is a long time to do something you're not sure will work. There were months, and I want to be honest here. There were months where Loretta thought about stopping, where the rational part of her brain said, "This is not your expertise. You are going to embarrass yourself. The other side has a team of professionals, and you have a printer and stubbornness." She kept going for one reason that had nothing to do with the law. She kept going because she had sat at that kitchen table and watched her father show her a folder he'd kept above his refrigerator for 22 years. A man who saved every document, who believed in the permanence of things that were written down, signed, filed, who trusted that the rules meant something, that if you followed them, they protected you. He had been right. He just hadn't known which rule. She knew, and once she knew, there was no version of herself that walked away. James Caine received his payment in full 6 weeks after the judgment. He did not reopen the dry cleaning business. He was 63 by then, and his knee had not fully recovered, and the industry had changed in ways that made the economics harder. He knows that. He's made peace with it. He used part of the money to pay back what he'd borrowed from his sister over the years. Some of it he saved. Some of it he gave to Loretta, who refused it twice and accepted it the third time, because James Caine, once he has decided something, does not change his mind. Arcadia Financial Group is still operating. They are still acquiring commercial properties across Georgia and several neighboring states. They have, since the Caine judgment, updated the language in their standard acquisition addendum, which means if you read between the lines that they know what happened, they know why it happened, and they quietly fixed the thing that Loretta Caine broke open. That's not nothing. That's a policy change. That's the next James Caine, whoever he is, wherever he is, getting the 90 days notice he was promised. Loretta went back to her job in Atlanta. She still works in commercial real estate compliance. She still reads the entire document before she signs anything. She still keeps receipts. She told me once, and I'm telling you now, that the most important thing she found in 3 years of legal research wasn't a case law precedent or a procedural rule. It was that paragraph on page 5 of a 1997 lease that a 61-year-old dry cleaner had been carrying in a folder above his refrigerator for over 2 decades, not knowing it was there. The right had always existed. He just needed someone who would look. So here is what I want to ask you, and I want you to think about it honestly. If you had been in that courtroom, if you had seen Loretta Caine walk in with her worn blazer and her rubber-banded folder, and you had seen Preston Holt with his cart and his team and his 22 years of wins, what would you have thought? Be honest with yourself. Would you have assumed you knew who was going to win? Because I think most of us would have. I think most of us look at the size of the resources and we make a calculation and we feel like we're being realistic, and what we're actually doing is deciding the outcome before the evidence is in. What Loretta understood, what her father had always quietly understood, even if he'd never been able to act on it, is that the document doesn't care who's holding it. The paragraph doesn't know what you're wearing or how much your cart of files cost. The words are the words. She read every word. For 3 years, alone at her kitchen table, she read every single word, and that was enough.